Now it's my pleasure to introduce Travis LeBlanc, the first of our two keynote speakers. Travis LeBlanc is the Chief FCC Enforcement Bureau he's the Chief of the FCC Enforcement Bureau, the Commission's largest organizational unit. The appointment announced about 1 year ago by FCC Chair Tom Wheeler, who called him a, quote, savvy prosecutor who also knows how to secure agreements with private companies in order to advance the public mission. Last summer, Mr. LeBlanc shared his perspective of the role of the Enforcement Bureau with members of the Federal Communication Commission Bar. He promised that the Bureau would be committed to 4 core values: protecting consumers, safeguarding competition, policing fraud, and securing networks. He also promised to focus the Bureau's efforts on preventing problems rather than reacting to them. Mr. LeBlanc is well prepared to assume the challenges of his office. Before joining the FCC, he served as the top deputy and senior advisor to California Attorney General Kamala Harris, the largest state attorney general office in the country, established and oversaw California's first high-tech crime and privacy units, secured global agreements with several high-tech companies to protect consumer privacy, promote online safety, and to respect the intellectual property rights. That office has really been a groundbreaking office in this area, and it must have been a super experience being there. He's been an attorney with U.S. Justice Department's Office of Legal Counsel, which advises the President and the Attorney General, in private practice with Kecker and Van Nest in San Francisco and Williams and Connolly in D.C. And he was a law clerk to the Honorable Stephen Reinhardt on the U.S. Court of Appeals for the Ninth Circuit. He's no stranger to academia, A.B. Princeton, MPA Kennedy School of Government at Harvard, and a J.D. from Yale, and an LLM in international law at the University of Cambridge. He seems to like being around school as much as I do. Currently, he's an affiliated scholar at the University of California Hastings School of Law. It is my pleasure to present to you Mr. Travis LeBlanc. Thank you.
Good morning, and thank you, Dean Tobin, for that warm introduction. I also want to thank the Journal of Business and Technology Law for inviting me to the law school to kick off today's exciting symposium about the impact of the First Amendment on American businesses. While this is my first time visiting Maryland Carey Law School, I am fortunate to have worked with a number of your alumni over the years. I presently, in fact, I work with Shantae Willis, or as she was known here, Shantae Knox, a member of the class of 2005, and she works in my bureau at the Federal Communications Commission. And of course, I'm lucky to have a number of friends on the faculty as well. As the dean said, I'm no stranger to academia. Danielle Citron, who's here with us today, David Gray, Michael Pinard, Thiru Vignaraja, among others. So it is truly a pleasure to be here. And Dean Tobin, let me tell you, you have lined up 3 fascinating panels on commercial speech, religious exemptions, and the First Amendment's impact on technology. Needless to say, these are challenging issues. And looking over the agenda, it seems as if I may be the only government official on today's symposium. And in my comments this morning, I hope that I could provide some useful insights on how we, at least those of us working in enforcement at the Federal Communications Commission, promote the First Amendment and protect the public in the 21st century. I'm sure that it will not surprise any of you that since I joined the Federal Communications Commission about a year ago, I've spent a lot of time thinking about how we communicate in the 21st century. Indeed, I often joke that communications is our middle name at the FCC. And more these days, I think about how the internet, and in particular, internet access, intersects with our collective rights to communicate as guaranteed by the First Amendment. But today, I want to talk about the First Amendment and the public square of the 21st century, this thing we call the internet. I want to talk about why the FCC's Enforcement Bureau has a growing responsibility to ensure continued, meaningful access for all Americans to a free and open internet. I want to talk about the ways we are striving for universal access to these vibrant 21st century shared spaces, and I want to talk about the difficult challenges we face when a limit on communications seems necessary to promote the fundamental values, including oftentimes those of the First Amendment itself. First, though, I want to talk I want to acknowledge that while we at the FCC most frequently encounter the First Amendment through the speech and press lenses, we're always conscious of the amendment's broader underlying values. While much has been written about the First Amendment in the last 225 years, and I'm confident even more will be said about it today, it is clear that the First Amendment protects more than just the right to speak, publish, or practice one's religion. The First Amendment's individual and collective rights are founded on a bedrock of liberal ideals: freedom of conscience, individual expression, diversity, tolerance, political equality, democratic deliberation, transparency, accountability, civic engagement, and self-government. Indeed, the author of the First Amendment, James Madison, noted that the right of freely examining public measures and characters and of free communication among the people thereon is justly deemed the only effectual guardian of every other right. In short, the First Amendment is the foundation upon which our Republican government survives and thrives, and the values underlying the amendment are paramount. Our responsibility as government actors, my responsibility every day as the leader of the FCC's Enforcement Bureau, is to take positive steps to protect and nurture these fundamental values. Now let's go back now, though, to when the First Amendment was adopted, and the locus of speech, of free speech, was the public square, when people literally took to the town square to get their message out, where citizens gathered, traveling to come together and share not just opinions about politics and religion, but about business and art, and of course, their neighbors. Everyone has the right to speak, write, or publish what he wanted, subject to minimal government restraint. But here in the public square, your opinion could reach only as far as the limits of your voice. Today, though, the locus of free speech is not the public square, it's the internet. Instead of getting on a bus and riding to the public square, we go online to share and debate our views via tweets, meerkat videos, Vine, or, nowadays Periscope as well, Vines, Facebook posts, blogs like Generation JD, and even academic writings like all 5 of the law school's journals. In this digital public square, we can speak at any time from anywhere. There is virtually no limit on who we can reach, and just as important, our listeners do not have to be present or tuned in when we happen to speak, and they can participate by responding instantly or whenever they choose. As one early internet activist noted over 15 years ago, the internet is a common area, a public space like any village square, except that it is the largest common area that has ever existed. Now, this has only become truer over those 15 years. Indeed, 15 years ago, Mark Zuckerberg was 15 years old. Today, 74% of American adults use social networking sites, and 93% of Americans over the age of 5 are online. So the internet is the new digital public square. It represents the most robust experiment in deliberative democracy that the world has ever known. Indeed, Ai Weiwei has argued that the internet creates an unprecedented ability for transparent civic engagement by ensuring that debates are not ended by a single pronouncement from an official voice. And I quote, "The internet is like a tree that is growing," he writes. "It allows the last word to come from even someone with a very weak, quiet voice." Everyone can speak on the internet. Everyone can publish. Everyone can broadcast. Everyone can assemble. This fundamental shift in where we exercise our First Amendment rights has been accompanied by a fundamental shift in technology that each of us needs to engage in that speech, whether we want to create it, to receive it, to publish it, broadcast, or debate it. The implications of this technological shift are profound. Let me give you an illustration. For me to get from here to an actual public square, to say my piece on days I haven't been provided with a podium and a captive audience in Baltimore, I need to hop on a train or bus or possibly drive a private vehicle to the public square. Access to the public square requires access to transportation. This is because true freedom to speak, true support of those fundamental First Amendment values means you must be free to speak where others are free to join you, to hear what you have to say. As Chief Justice Berger said, free speech carries with it some freedom to listen. But what if I want to engage in a protest online, post a YouTube video, Or say, stream John Oliver's show on HBO Go, and then email a federal commission because I realize that the proposed open internet rules are important to me. I still need to get to my listeners, but trains and buses are not going to take me there. The internet, or more specifically, my broadband provider, is. As we at the FCC experienced firsthand after John Oliver's coverage of our proposed rulemaking, the internet is the most participatory public square the world has ever known. Let me say that again. The internet is the most participatory public square the world has ever known. The internet is where people assemble in the 21st century. It's where people gather for fellowship. To enter and participate in this 21st century digital public square, I need access to the internet. My smartphone plan is the train. My ISP is the bus. Yet because the internet's bus lines are generally not publicly operated, this has major implications for how we exercise our free speech rights in the digital public square. With some important exceptions, like the Wi-Fi here at UMD and some municipal broadband systems, there is no public transit system to access the digital public square. 17% of Americans have no broadband access at all, and unlike the physical public square, I do not even have the option to take my own car to get there, which is to say, it's not feasible for individuals to run their own private broadband service to access the internet. The American Information Superhighway is largely owned and operated by private companies, often very big megacorporations. While the United States may not have much government regulation of the internet, individuals do need to pay private corporate providers to access and to assemble in the digital public square. The Supreme Court has made clear in the broadcast context that it is not the purpose of the First Amendment to countenance monopolization or of the market for speech, whether it be by the government itself or a private licensee. So government regulation is not our only concern here. We're mindful that both accessing and assembling in the digital public square are susceptible to curtailment by corporate regulation. Here in the United States, those in the best position to protect access to the digital public square are the state and federal agencies like the FCC that have authority over the provision of communication services. So how in a world where internet access is dominated by private corporations can we at the FCC protect the vibrancy of the digital public square? As I see it, the Commission has embraced three strategies: fostering competition, promoting universal, open, and free access, and imposing real consequences for practices that are unfair to consumers. Fostering competition is an essential place to start. In the ideal internet marketplace, every citizen would be able to choose from multiple bus lines to the digital public square. As Chairman Wheeler said at this year's Consumer Electronics Show, competition in the broadband space is key, but for 3/4 of American households, there is only one or no broadband bus line available, at least if we're talking about high-speed buses. Market studies show that Americans generally have at most 2 or 3 choices. What does it mean for an individual's exercise of her First Amendment rights if her ability to access the digital public square is owned and controlled by one or just a few businesses? With few options and ever-growing demand, those offering internet services have more ability to control the terms of services, what content you can access, when, how quickly, and at what price, without worrying at all about competition or consequences. These corporate regulations can pose as much of a threat to the fundamental values underlying the First Amendment, democratic deliberation, political equality, accountability, that list I gave you, as government regulation would pose. And as the ACLU has pointed out, freedom of expression isn't worth much if the forms where people actually make use of it are not free. Real competition means ensuring that there are more broadband options available to individual citizens. It means ensuring that there is real broadband competition within geographic markets. Municipal broadband networks, which are provided either fully or partially by local governments, are one way to make this a reality and bring real competition into the communities by being the public transit route to the digital public square. And I do want to emphasize that this is real competition. As an article in this month's Atlantic Monthly points out, when government entities compete directly with private competitors, there are service improvements to all citizens. The Commission recently acted to foster this kind of meaningful competition in broadband by creating space for the growth of muni broadband services. While there are currently small muni broadband deployments of various types across the country, there are at least 19 states that have passed laws to restrict the growth of existing muni broadband services or the creation of new services. Indeed, this has been in the news in the last 36 hours when a journalist, I think for The Consumerist, had difficulty trying to get internet access at this new home that he purchased in Washington State when there was, a muni broadband service nearby that had gigabit service, and he couldn't get it to his house at all. The Commission recently got a petition from muni broadband providers in Tennessee and North Carolina who have been prevented from expanding their service due to industry-backed state laws. The Commission acted to preempt these laws and, in the words of our chairman, allow local communities to make their own decisions about their broadband future. Let me give you another example of how we have worked to foster competition. My team in the Enforcement Bureau recently took aggressive action to promote competition and access to the digital public square, in our case, in hotels and convention centers. We found that Marriott Hotels was blocking the use of personal Wi-Fi hotspots at one of its convention centers and charging guests and visitors up to $1,000 per day, per device, to access the digital public square and to use its slow, overloaded hotel Wi-Fi. To keep going with my bus metaphor, this is like letting the air out of the tires of the competing buses to force customers to ride your slow, crowded, and expensive bus. That, or simply forego a visit to the digital public square at all, to the locus of modern speech. The Supreme Court has been explicit that the right of free speech does not embrace a right to snuff out the free speech of others. Last year, we hit Marriott with an unprecedented $600,000 fine for blocking Wi-Fi and prohibited them from engaging in Wi-Fi blocking at any of their hotels. I am happy to report that our action started a national conversation about hotel Wi-Fi charges. Since then, several national hotel chains, including Marriott, have not only stopped blocking Wi-Fi hotspots, but have begun to offer free Wi-Fi to all guests. This is what encouragement of real competition looks like. Next, the Commission has embraced a strategy of promoting universal, open, and free access to the internet by putting in place baseline rules that apply to all broadband ISPs. The FCC is charged with protecting and expanding access to the main avenues of communication today, and consequently with protecting access to free speech itself. Protecting and encouraging the fundamental values of the First Amendment is not a new role for the government. From those original publicly owned squares to the early Federal Radio Commission's work to keep the airwaves clear, right through to the federally funded researchers who developed the foundations of the internet. The government's First Amendment obligations have always gone beyond refraining from acting to actively supporting and encouraging the exercise of First Amendment rights through communication. The Open Internet Order is a strong example of this approach. The order addresses wired and wireless internet service providers, but only in ways that ensure a competitive marketplace for internet provision that is fair to consumers and other businesses. As the Commission stated in its orders, our rules serve First Amendment interests of the highest order, promoting the widest possible dissemination of information from diverse and antagonistic sources, and assuring that the public has access to a multiplicity of information sources. The Commission was writing about the open internet, but they were actually quoting a Supreme Court decision about television. The focus of the Commission on these fundamental First Amendment values goes beyond any particular communications medium. The key provisions of the Open Internet Order that establish the rules of the road are prohibitions against blocking, throttling, and paid prioritization, and an enhanced transparency obligation. All four of these measures are aimed at not at stopping businesses from thriving, but rather at placing reasonable limits on business practices that have the effect of restricting exercise of your First Amendment rights in the 21st century, which is to say, of restricting access to that high-speed bus to the public square. Let me elaborate. The rule against blocking ensures that no broadband provider can prohibit its customers from using the internet to access lawful content, applications, and services. back again to our bus metaphor, broadband access is like a monthly bus pass. Once you have it, they can't refuse to take you wherever you want to go. The rule against throttling ensures that broadband providers can't selectively impair or degrade lawful internet traffic. For example, a customer's engagement with particular sites that the provider may find objectionable, not profitable, or competitive. To go back to our metaphor, no second-class tickets on these buses, and no driving slower to save on gas. And the rule against paid prioritization prevents broadband providers from favoring some lawful internet traffic over other lawful internet traffic in exchange for consideration of any kind, money or otherwise. Every bus has access to the same lanes wherever they're going, no express toll lanes. Providers can, of course, establish reasonable limits and rules to fairly manage their network, but at all times they must nevertheless be forthright and clear with consumers about what those are, as well as the commercial terms of their service. That's the function of the newly enhanced transparency rule, which requires providers to post clear notices before consumers sign up for internet service that discloses in a consistent format the commercial terms of service. It also requires accuracy in notifications and advertisements. In other words, ads on the sides of your broadband bus must be accurate, clear, and truthful. As I mentioned earlier, access to the digital public square is, for the most part, controlled by private entities. Before the Open Internet Order, they did, or at least could, limit access however they chose. The order pulls us back from the laissez-faire brink, establishing a floor of consumer, and I would argue, First Amendment protections to enhance the First Amendment values like diversity or individual expression or transparency. These are non-economic values that are not easily quantifiable or commodifiable. The Commission's Open Internet Order, and let me go one step further about these values. These values aren't easily traded in free market or protected by antitrust and competition laws alone. The Commission's Open Internet Order ensures that Internet continues to be, as Professor Tim Wu has called it, a hotbed of free speech. Free Press has called the Open Internet Order the biggest victory for the public interest in the agency's history because they see the digital public square as an unrivaled space for free speech, civic participation, innovation, and opportunity. Of course, the Open Internet Order is just the most recent example of the FCC's work to ensure access to the digital public square. The Commission has a number of initiatives in this area, including the pro-competition data roaming rules that help you stay connected on your mobile device, even if you're outside the range of a tower owned by your particular mobile carrier. The redefinition of broadband to refer to a more accurate 25 megabits per second minimum download speed, and the E-rate program that ensures access to broadband internet in schools and libraries. So I talked about multiple bus lines, and I talked about the rules of the world. What are the consequences for breaking those rules? Unsurprisingly, that's where the Enforcement Bureau has a big role to play. Under the new Open Internet rules, we have responsibility to exercise not only our traditional enforcement hammers, fines, settlements with compliance plans, etc. We're also empowered to deploy some more precise scalpels. New enforcement tools like advisory opinions, and also existing ones like enforcement advisories and publishing investigative reports. Our work enforcing these consequences will magnify the whole Commission's efforts to foster competition and promote universal access. Now, given that I'm the Chief of Enforcement at the FCC, I think it's important to talk a little bit about a difficult challenge we at the FCC face when a restraint on communication seems necessary to promote fundamental values. As I mentioned earlier, and as we all know, the freedoms protected by the First Amendment are not absolute and unlimited. Your freedom to assemble ends where my property begins, for example. There are situations where limits on First Amendment rights serve fundamental American values. Our challenge is to determine when such limits are appropriate and how to enforce them. A classic example of this challenge, one that the FCC wrestles with on a regular basis, is what the limits on broadcast speech are when that speech is arguably indecent or obscene. Indeed, many, if not most of you in the audience, only know the FCC through its role in this area. Students in the audience may have first heard of the FCC back in the day with Janet Jackson and Justin Timberlake. Now, your professors, by contrast, may have first heard of us because they were George Carlin fans. And I imagine that many of you have now heard about the case that we released on Monday, in which we planned the largest ever fine for a single indecent broadcast on a single station. In a human interest news story, a station, WDBJ, did a story about a former adult film star who had joined a local rescue squad. The television station displayed a porn ad that will, let me tell you, leave nothing to the imagination. It depicted nudity and graphic sexual activity on the 6 o'clock news. The commission takes this violation seriously, and although it was only a few seconds, it left an indelible print on many who viewed it. In the commission's view, parents rightfully expect that television stations will not broadcast sexually explicit images during dinner when children are likely to be present. Much like prohibitions on yelling fire in a crowded theater or putting time, place, and manner restrictions on which corner of the park a protester may set up her soapbox, the indecency laws, as well as our rules requiring broadcasters to disclose who is paying them to air political or commercial programming, these impose real limits on speech. But there are restrictions that exist to balance our First Amendment rights with the First Amendment rights of others, as well as the public values like privacy, public safety, and transparent elections. Of course, we have in this country traditionally approached regulation of broadcast and broadband in totally different ways. The government has taken a very heavy-handed approach in regulating broadcast television and radio, whereas it has had a light touch with broadband. As controversial as it is to set limits on speech on the comparatively small number of broadcast stations using the public airwaves, it gets much more complicated on the internet. One reason is the decentralized nature of the content online. And on broadcast television, we know who's speaking, the television station. And based on what time the speaking happens, we have a pretty good idea of who is listening. On the internet, however, speech can happen at any time and can be heard at any time, and the speaker is often totally anonymous. But speech in any form can cause genuine harm. And the nature of the digital public square gives each and every one of us both a megaphone and a mask more powerful than you could ever bring to the traditional public square. When I was at the California Attorney General's office, we saw many examples of this when investigating cases of cyberbullying and other cases involving teens and cyber harassment, and aimed in particular at domestic abuse advisors. And indeed, this law school's very own Professor Citron has brilliantly documented the problems caused by revenge porn or photo exploitation, as Danielle and I have proposed renaming it. These types of internet-based harmful speech raise profound questions. Who is responsible in these contexts? What is the best method to deal with the offending content consistent with our First Amendment values? Do we have to hold the bus drivers responsible for checking the ID of every person who boards on their way to the digital public square? And how do we draw the line between anonymous harassment, which most of us want to limit, and anonymous political engagement, which most of us, including the Supreme Court, want to protect? And what about when speech becomes invasive? Between the do not call list and our limits on using computer dialers, unwanted phone calls have diminished dramatically. But they remain by far the largest category of complaints we see at the FCC. Robocalls make up over 20% of calls in the United States. As more calls move to VoIP and other online services, we have to constantly be aware of not only how our rule applies in new spaces, but also why it exists in the first place. As Justice Sandra Day O'Connor has said, the government's interest in protecting the well-being, tranquility, and privacy of the home is certainly of the highest order in a free and civilized society. Thus, one's right to privacy from speech can, in certain situations, trump others' rights to speak. These are tough issues. As government regulators, we have a responsibility to protect and promote the First Amendment and the fundamental values that underlie it. Whether we are asking how best to clear the roads for access to the digital public square, or how best to protect the public square and all American citizens from its misuse, we're guided by the prescripts and values underlying the First Amendment. We in the government have a responsibility to protect the public square and access to the public square, whether that is a physical or digital space, and our responsibility at the FCC has only grown as technology has moved communications further and further into the digital public square. Protecting the public square means more than just making room for soapboxes and keeping the broadband bus lines open. Sometimes it means balancing the rights of multiple speakers, or of speakers and those for whom the speech is invasive and destructive. Fundamentally, our role is and always will be to ensure that the access to the networks, and that we can ensure that people can come together across the nation and across the world. In the 21st century, this means we need to ensure that we all have access to a free and open internet. Thank you.